Welcome to yet another episode of Beyond the Eye Investment Properties. And I'm your host, Buzz D.
Simon.
And together we strive to empower and to make sure that our people understand the processes of real estate and the ones and twos, the do's and the don'ts of buying, selling, acquiring, or even other ways of acquiring real estate. And today we are joined by Silvia Maree, who is our guest, to come and chat about some of the things that she has encountered in this journey. Good afternoon.
Good afternoon. Thank you very much.
Okay.
It's nice being here and being part of your podcast. I'm Silvia Maree from CBI Attorneys. And let me just tell you, firstly, why you should use CBI as your preferred attorney.
Right.
We open up accounts within 24 hours of receiving your offer to purchase.
Wow.
We have quick turnaround times. We have contacts in all the councils, Joburg and Tshwane. We also have specialized people that go out to your clients to sign documents. So we do not insist that customers come to our office.
Right.
We go where it is convenient for your clients. Thus, that speeds up the turnaround time.
Right.
We also have our own in-house bridging, which means when your deal as an agent is secure, we can advance you of your commission, and we don't charge you any interest. We'd also advance your sellers where they don't have the funds to pay for their rates.
Wow.
So we will recoup that on from the proceeds on registration.
Wow.
Okay. We also have litigation, which means should your deal collapse and the seller pulls out,
Right.
we can then litigate for your commission.
Wow.
And if we are successful, then we will take a percentage, 30% of the proceeds. Right?
Very nice.
Yes.
Very, very nice. How long are you in this business?
Okay, the housing business, that has been for a very long time. This journey started way back at Standard Bank Home Loans.
Wow.
Many, many years ago.
Yeah.
Yes, I'm passionate about home loans.
Mm-hmm.
We also, getting into the branch network, you worked almost as a bond originator.
Right.
Because those years, the agent would come with the applications to us. You'd sit there in front of your computer, you would process the application, and you knew there and then, within a matter of minutes, approved subject to evaluation. We were then also in a position to contact the assessor if he is available the next day to go out and do evaluation, that kind of thing.
Right.
Right? And then eventually coming into CBI Attorneys. I have been with CBI Attorneys for just over 9 years.
Wow.
So you'll find that the interaction with estate agents from working in the bank and being in the attorneys, the differences is there's hardly any. Very similar.
Yeah.
So yes, and very passionate because when a client acquires a home, my goodness, what an amazing feeling that is.
Oh man.
And we have to be passionate with them. Bond originators are just as excited when that bond is granted.
Yeah.
That's true.
Because also that's important for you as an estate agent.
Yeah, and that is a big deal. Acquiring a property is a big
It's a
deal.
big step,
major.
Yeah.
Yes.
But what inspired you to do what you do, Silvia?
Firstly, I love working with people.
Right.
So, having all these relationships with your bond originators, with your estate agents, to me, that is absolutely amazing.
Yeah. I'm sure you have some of incredible stories to tell. I mean, you've been in this business for quite some time now. What do you remember as maybe that stands out as one of the greatest moments with your journey so far?
What we do as from CBI Attorney,
Right.
what we also do, and what is amazing for us, we have facilitators where we offer workshops
Right.
to our agents. And when you see the excitement when an agent gets that knowledge from what the facilitator is telling them.
Yeah.
And when we see that what they apply, what the facilitator, and it's improving how they do business, and it grows their business, nothing can be more satisfying.
Oh man,
Because
and that is incredible.
if your business as an estate agent grows, so do our business grow.
Incredible.
Because it's a circle.
So all these things are intertwined.
On one another. It's all intertwined.
But
that is
I agree 100% with Silvia what she just said now. The support that we received from her, you'll see or gazebo, you see, and they will arrange workshops where we learn about property trade and so forth. You know, you were there.
I was there.
Yes, I mean that's what differentiate CBI from other lawyers that I've worked with. Thank you so much. I really appreciate it.
And we
Silvia.
look forward. There's a few sessions coming. So we've got the next one coming on Thursday, and we look forward to see you there. More knowledge, more power.
Wow.
You have given us a beautiful rundown. Like you have laid a proper base on what do you do. But one wonders, what exactly is the crux of conveyancing in the business of real estate?
Look, a property transfer cannot happen without a conveyancer.
Right.
Really? Silvia, before I've got but you'll agree with me. Most of the clients that we have on radio, they will say that they bought the property through affidavit, and they've just changed the locks and give this one gives the title deed. Are you sure?
Now,
the dangers of that.
Now, that is a big problem because now you find whoever's name is on the title deed, if that transfer did not happen, even though I paid you money, you had the affidavit, but I didn't go to an attorney or conveyancer to have this transfer done, the property still remains yours.
But
in
these people,
the event should I die, my family has got no claim to that property because it is still saying this property belongs to Simon. And Simon's family, what if Simon is not there anymore? Simon's family will say the title deed is lost. Even if I've got that title deed with Simon's name on it, it means absolutely nothing. My name is not on that title deed. So at the end of the day, we have many cases like that. You know, people are excited. Yes, I'm giving you 100,000 or 150,000 for your property.
As if they are buying cookies at the spaza shop,
and it doesn't work that way. Now you find, yes, I go ahead and because I am none the wiser. I don't know the process. Sometimes we cut out an agent because we don't want to pay the commission. But if the agent was involved, the agent would have guided us as potential buyer and seller.
Correct.
Guys, we have to employ the services of a conveyancer to make sure the property is transferred from your name into the next person's name.
And I'm glad, Silvia, you're actually touching on that because, like you said, this is like an elephant in the room. I mean, where somebody has worked so hard over the years and they get to their retirement age and then the company pays out. And now this person is sitting with so much money and they go out and search for a property, get a property that is almost the same amount as the payout from, and then unfortunately, through lack of knowledge, they go and maybe speak directly to the seller to say, no, I have cash, I want your property. And then they go to the nearest police station. They sign an affidavit. They say, okay, I'm buying your house. So this person says, okay, yes, you're going to pay me so much. And they exchange, the one gives the key and the other one gives the money.
Yes.
Is that the correct way of doing it?
Definitely not.
What is the correct way then?
The correct way is before I give my money away.
Right.
Let me find out. There's many estate agents around.
Mm.
I can just pick up the phone an agent. Okay, I want to buy this property.
Right.
What is the process?
Mm.
Because guys, if you sign your money away, I give my money away. Should whoever I'm giving my money to,
Yeah.
that person passes away,
Mm.
what proof do I
So there's
have?
no OTP?
Yeah.
There's no deed of sale?
No, there's no agreement whatsoever. Just the affidavit from the police, which means absolutely nothing.
And even you're not even sure that the person that you are signing or
Is the
exchange
owner.
is the
Is the
real
owner.
owner. You.
Yes,
No.
You
So
have
that
to
is
make
that
sure-
that is basically a dangerous way of buying or acquiring a property there.
Yes, you could find that somebody has taken somebody else's title deed. Yeah, they
And it happens a lot.
It does happen. This is my property. Yeah, I'm taking the money. Whereas, if you were an agent, you would make sure. Let us do a deed search
Right.
to make sure that this person selling this property is
Mm.
the correct owner of this property.
Yeah.
You do get people who take chances, and where they can grab your money, they'll do that.
Right.
And you see many people cry because they didn't know.
Mm.
So, yes, you find people also do that because they do not want to spend money on the conveyances fee to do that transfer.
Yeah.
They want to cut the corners.
They want to cut corners, and the thing is they create a huge loss to themselves. Because should the person that they've given the money to, let's say that person passes on,
Mm.
and that person's family decides, no, this house is not for sale.
Yeah. It was never for sale.
According to them, where is that affidavit means nothing.
Yeah.
So now, I cannot come and claim and say I bought this property
Mm.
because
And in most cases, you have also renovated the property.
Wow.
You have now changed a few things. You have spent, and now the person comes and say, no, but this is my dad's property.
as a matter of fact, talking about that, let me give you a scenario.
Right.
Last week,
Hmm.
we had an inquiry where the agent is now going to sell this property, but
Hmm.
the person wanting to sell the property
Hmm.
bought this property 18 years ago.
Right. 18 years.
18 years ago.
Wow.
Where he paid 100,000 rand for the property.
Hmm.
He's sitting with the title deed in the other person's name. They
Aish.
never went through the process. He has renovated the property, he has built rooms. Now he wants to sell. He cannot sell that property because it is not
his property.
The owner of the property is still around. Now that owner is refusing to sign documents because that owner now
man.
knows the property has
Oh,
acquired
man.
value
Oh,
and the
man.
property has changed dramatically because of the improvements.
Right.
So she would rather want to buy the property back and give him his money back. It does not work that way.
Sure.
Mm. Mm. And
That is something that they have to sort out amongst one another.
yeah. And what would be your advice in this scenario that you've just given us? What would be your personal advice on this particular one?
You see, firstly,
Hmm.
that seller, the original seller, the owner of the property,
Right.
is refusing to sign.
Yeah.
She is not willing to sign documents now for the property to be transferred from her name to the buyer of 18 years ago.
Sure.
Very, very, very interesting.
So, at the end of the day, you cannot force that person
Hmm.
to sign.
And unfortunately, she's got a title deed that backs
She's
her
got
up.
a title deed, which means she can sell that property
You know, the other issue.
unless they come to an agreement
Yeah.
and she sells the property.
Right.
This guy might have to count his losses.
Hmm.
So she might take an amount bigger than the 100,000 originally. There is that
But
possibility.
there is no law that
There's no law.
that forces her to.
That's right, because she's the owner of the property and she can do as she pleases.
And you know what also, while we're still on this issue,
Yeah.
the other issue that is also a serious issue is this family house issue.
Yeah,
or
that
family
one.
houses.
The family houses where an uncle, a scenario would be both parents are now late. We are left with our a late estate,
Yes.
and the title deed is still on our parents' names.
Yes.
And then myself and Simon, we are the beneficiaries of this property. But now I go and sell the property behind Simon's back. Is that not crime?
It is crime. You see, there are times, but then you find also you have had bad intentions to cut Simon off in the beginning. So therefore you sold the property. There is situations that happen like that. So you'll find there might be ways that they found for an attorney to do this transfer for them.
Right.
You know, in most cases you find when a letter of executorship is issued, sometimes people want to cut others out. You find sometimes parents might have had children outside of the marriage. They are heirs to that property as well.
Very interesting.
The master might come back. So when we apply for a letter of executorship, because the property is now going to be sold, the master will come back and say, there is
another
child.
Yes.
You have to find that child. People want to discard, but they can't. The other person must come forth and sign the consent to that property being sold. You might be scared that they want their share. They might turn out and say, you know what, I'm happy for you to sell it.
I want nothing to do.
But you were afraid that they would want something. So you decide, let me discard it. But you cannot move forward without them also agreeing to the sale of that.
But while you are still on that one, what does the intestate, they call it intestine, whatever says
so
about
when you die
estate?
intestate, that means you did not have a will.
Right.
So there is where the master now comes in, right? And you find if you had a will, you would be specific in your will. The property needs to be sold. Pasi must get 50%, Simon must get 50%, my sister's child must get or 30%, 30%,
right.
And my sister's child, whom I love so much, must also get 30%, and then my sister's grandchild, whom I love so much, must get the other 10%.
Right.
So then that is carried out because that was my last wish. Right? But in the state, that is now when the scenario is different. And sometimes you find those siblings staying behind are fighting because, but now this is how it works. Let's say maybe in the case where one spouse passed away, not both, one spouse passed away. They were married in community of property. So that means the surviving spouse owns 50%. The other 50% of the deceased. Now let's assume there is 2 children born of this marriage.
Right.
They are the only 2 children. There's no other children. So let's assume this property is worth 800,000.
Right.
The surviving spouse owns 400,000. The deceased has 400,000. So in terms of the interstate, regulation says the surviving spouse will inherit 250,000 or a child share, whichever is greater, of the deceased portion. So we determined 400,000 belongs to the surviving spouse. The other 400,000 of that, 250,000 goes to the surviving spouse.
Right.
That means there's a balance of 150,000, which will then be divided amongst the 2 kids.
I see.
If that property was valued at 500,000, the kids would also sign their consent that the property can be sold, but they're not going to inherit anything because the surviving spouse gets 250, and then remember, child share 250. Whichever is the greater, there is just 250 left, which means the surviving spouse gets everything, and the children won't get anything.
We will expand on this because this is now eye opening, but before that, I want us to have just a break to drink water, and when we come back, we'll carry on.
Thank you.
Welcome back from the break. Sylvia, we are on the point of the late estate.
Yes.
So, with all the problem that goes with,
Okay.
as you did mention, but I just want to ask you something.
Sure.
The letter of authority, the executorship, how do you? What is the difference?
There's a difference between the two. A letter of authority is issued for any asset under 250,000.
Right.
That means up to 249,999. Letter of executorship 250,000 and above. So, if, for example, you are going to sell a property, let's say RDP,
Yeah.
and the person wants 250 for it,
Okay.
don't sell it for 250. Sell it for 249,999.
Right.
So that we stick within the letter of authority,
Mm.
because with authority, it is just for the master to endorse the power of attorney that
Okay.
the property can be sold, and then on registration, all proceeds are paid out. But the minute it is a letter of executorship, now the winding up comes into place.
Yeah.
Which means now there is the advertising in the newspaper, your section 29 and then your section 35 and the gazette and that kind of thing. And that becomes expensive because now you're going to look at the winding up, which equates to 3.5% of the estate plus VAT. And then there is the cost of the advertising. There is the cost of the letter of executorship. So, if you have that scenario where you can keep it under 250 for letter of authority, do that. But anything, remember, 250 and above, it is a letter of executorship.
And you know, I just want to ask this, and for the benefit of somebody who is watching at home,
Yes.
to say some people omit important information intentionally, like a scenario that we can make. If the deceased is the man or the father,
Yes.
and he has, say, 4 kids,
Yes.
but 2 are outside the wedlock,
Yes.
and the woman would go and obtain the letter of executor or the letter of authority,
Yes.
omitting the kids who are outside of wedlock. What are the consequences or repercussions of that?
Or is it possible?
Look, when,
Or is it even possible?
look, when the master has to endorse the power of attorney, or when an estate is reported before that letter, especially when it comes to letter of executorship to be issued,
Yeah.
where we intentionally leave off, sometimes you find with the breach birth certificate, the master will come back and say, there is another child, there's 2 children,
Yeah.
or whatever the case may be.
Right.
So then you cannot hide those kids. But if there is no breach birth certificate indicating the details of both the mum and the dad, there is those that do slip through.
Yeah.
Where they can get away with it. But remember also, sometimes people omit information of others because they're scared that they're going to inherit. But as we explained earlier on, depending on the amount of the estate, there could be instances where the children do not inherit anything because of the regulation. You own 50% and then the surviving spouse will get 250,000 or child share, whichever is greater.
Right.
So sometimes they deliberately omit children, but in terms of the estate, the children wouldn't inherit anything.
So in essence, they don't really have anything to fear
Yes.
or to be fearful of because of regulations.
Yes.
Yeah.
And the thing is that sometimes they don't know. They just think, oh, it's 50-50. They don't know that they would also inherit a portion of the deceased spouse. They're just thinking the deceased spouse portion will be divided amongst all the children. No, unfortunately, it doesn't work.
It doesn't work like that. Yeah. Which is brilliant. I mean, from where I'm sitting, I think that is brilliant, honestly. And one other thing that is also commonly done by people is this thing of not leaving a will. You know, a person has an estate, but they don't have a will, and unfortunately, after an unfortunate incident, then it's just chaos.
That's right. So we cannot stress enough. In our firm, every time we sign documents with a client,
Right.
there is the will application. Because these days it
Incredible.
is very important to have a will.
Yeah.
Because then you would stipulate there what must happen with your estate. Instead of you passing on, now you've got children and one child wants to feel more entitled than the other child to the property, and there's continuous fights, nobody wants to sign, and you as an estate agent just have tremendous difficulty in trying to sell that property.
Yeah.
Because until the kids staying behind cannot come to an agreement, you are not in a position to sell.
But on that part of the will, what advice would you give to someone that is watching? To say, can I just do the will? It's me and my child. Then she's a witness there on a piece of paper. You need a professional.
Look, the best thing, sometimes the banks offer wills as well. And if the bank is holding your will, the bank will become the executor of your estate. There's many, if you see them advertising, there's Wills Week when many firms are advertising. Or you find there's institutions that specialize in the administration of estates. And it will be advertised on TV. So the knowledge is out there to say, create a will for when you are gone. So we as attorneys, we also do will. So you don't pay for us drafting the will. The only thing is we will be the executor of your estate in the event where you pass on.
And that's how it should be.
Yes.
That is the easiest way and the most respectable way of executing the estate. I mean,
Exactly.
It leaves much to be desired if you have an estate and you do not even have a will in place to can actually execute your and then you live chaos. You live
chaos if you don't have a will.
Yeah.
Because you don't know how your children are going to react towards one another.
Yeah.
Sometimes one feels, oh, I should be the one. I'm the eldest. I should inherit. Yet you, the eldest, has never been there to take care of the parents.
Yeah.
The one that is always looking after the parents is now kicked out. There are times as well, and it has happened, where the parents feel, all right, this is the only child that is taking care of me.
Yeah.
And sometimes a parent feels, let me transfer the property to the child while I am alive. When that parent passes, the family still gives that child serious problems. Like you are not really entitled. Now you find, we've had cases where you find now the uncles come.
Yeah.
And they say, this was my
the uncles.
This is my sister's property. So you, the child, have got no say.
Yeah.
Because they feel we are the eldest.
Yeah.
And this is how we will deal with this property.
Maybe
very interesting.
Let's close this estate matter.
Yeah.
And to wrap it up, I just want to ask you something.
Sure.
If the person wants to, my thought, where is my thought?
Yeah.
I wanted to say this.
Right.
On the part of the will.
Yeah.
Whereby the other party doesn't want to sign. You've got a letter of authority, and you are both two. One wants to sell the property, the other one doesn't want to sell the property. Does the law forces this one that doesn't want to sell the property to sell, or what is the situation there?
Look, it's going to depend what the will says. The will is the one that proceeds, that takes precedence over everything else. So if I say in my will that this property must go to Simon, even though I have 3 others, but it must go to Simon.
Yeah,
but
only Simon will sign the document.
But I'm saying on the part of where there was no will, there is a letter of authority.
Yeah.
There are just two children that are the co-own the property, but the other party wants to sell because it's not staying in the property. This one is benefiting, doesn't want to sell. What law says in situations like that?
Can the one who wants to sell the property if they both do not agree?
The master will not sign. He will not endorse the power of attorney.
There you have it.
Yeah.
So
There
they
you have it.
have to come to an agreement.
Yeah.
Yes.
So as we wrap it up, thank you so much to Silvia
Thank you.
Maree. Silvia, to anyone who needs advice in terms of estates, where can they get hold of you?
We do have a deceased estate department,
Okay.
so they can contact me directly. I'm sure you're going to be advertising myself
Of
on
course.
the podcast.
Of course. Of
So
course.
yes, we will put them in touch with our very, very experienced people in the office that will do the winding up of the estate.
Thank you so much for your time, man.
Thank you very much.
There were so much questions that we prepared for Silvia, but because of time.
Time,
Hey,
man.
time.
Time is an enemy. Yeah.
We'll cover them in the next one.
Thank you very much.
Thank you very much.
Ladies and gentlemen, look out for our next episode where we will be empowering, educating, and making sure that you learn one or two things about estate agency. Thank you so much.
Thank you. Thank you, guys.
Hey,